I'm Scott Hervey with Weintraub Tobin.
And I'm Josh Escovedo with Weintraub Tobin. The United States Patent and Trademark Office has suspended action on trademark applications, taking advantage of a new appellate decision that would allow people to license trademarks that poke fun at the names of living people. That's what we'll be discussing on this installment of the briefing by the IP Law Blog. Scott, have you heard about the recent guidance issued by the U.S. Patent and Trademark Office on trademarks that make fun of living public figures?
I have, Josh, but why don't you tell our listeners what's going on?
Well, the USPTO has announced that it is suspending action on any trademark application that tries to take advantage of a new appeals court ruling that potentially allows people to license trademarks that make fun of the names of living figures like former President Donald Trump. The Trademark Office has indicated that it will continue to do so while it awaits guidance from the United States Supreme Court.
Right. And according to the one-page document issued by the Trademark Office, its examiners will not look at trademarks that cover phrases that are critical of government officials or public figures. And this is in line with the agency's long-standing rules. This is because Section 2C of the Lanham Act bans the issuance of trademarks that includes the names identifying a particular living individual without their consent.
You might be wondering what led to the issuance of this guidance. Well, last year, lawyer Steve Elster was trying to land a trademark protecting his use of the phrase Trump too small for use on t-shirts. Both the office and its own appeals board, the Trademark Trial and Appeal Board, had refused to register the mark, citing the office's long-standing rules. But Elster appealed the matter to the Federal Circuit, and there, Judge Timothy B. Dyke held for a unanimous panel of 3 that the government had no legitimate interest in protecting the privacy of President Trump.
Yeah, I remember hearing about this last February.
Yes, Elster argued that the phrase was political criticism, and according to Judge Dyke, it is therefore protected by the First Amendment. The USPTO has appealed the matter to the Supreme Court, and in its petition, the PTO argued that more clarity is needed than the Federal Circuit provided.
Trademark Office argued that Judge Dyke's reasoning was twisted because handing out trademarks that include political criticism of notable figures would actually limit that kind of speech. Specifically, the office stated that it is the registration of marks, like the respondents, not the refusal to register them, that would chill such speech.
So for now, the Trademark Office has said it won't take any action on trademark applications that are trying to take advantage of Judge Dyke's decision until the Supreme Court weighs in. It's unclear how many applications this will impact, as the office has declined to comment on its decision. One has to wonder what the Trademark Office will do if the Supreme Court refuses to grant cert on the issue, like it often does.
That's a real interesting question, Josh. Even if the Supreme Court were to affirm Judge Dyke's decision, it could lead to even more interesting issues down the road. For example, would such a decision mean that the trademark examiner would have to make a decision about whether a particular trademark expresses protectable speech under the First Amendment? That isn't always the most straightforward analysis to make in the legal world. It's interesting, Josh, how the Trademark Office got here, just as an aside. It seems that they could have issued a refusal to register this mark based on it being merely ornamental. And because my understanding, it was just for t-shirts and things of that nature. And the only way to get around an ornamental, there's a couple of ways to get around an ornamental refusal, but those factors don't seem to be here. I'm going to imagine that, assuming the Supreme Court even were to affirm Judge Dyke's decision, or if the Supreme Court refused to grant cert and Judge Dyke's decision was left to stand, we'd probably see more aggressive, merely ornamental refusals to register where there is a mark that is or includes criticism of a living individual that's a public figure or a political figure. What do you think about that?
I think that's right. I think that, this was one way to go about it, but I agree the ornamental use argument could stand. So I think that the PTO, depending on how hard it wants to push back against this, could go that direction.
Yeah.
I mean, I guess we'll have to wait and see.
Yeah, it's really an interesting issue, Josh. Thanks for breaking this down for us.
No problem, Scott. Thanks.
Thanks for tuning in to this installment of The Briefing by the IP Law Blog. Please remember to subscribe to our podcast and our YouTube channel and leave us a comment if you so choose. And if you're interested in more content like this, well, we have over 100 episodes for you to choose from, and you can always visit us at the iplawblog.com.